case points out the importance of understanding the correct interpretation of affiliate and control securities under US securities laws. Misrepresenting such relationships can lead to serious legal consequences, and in Gray's case, resulted in prison time and significant fines and penalties. An emerging rule of thumb indicates 10% ownership as a potential sign of control. However, the individual circumstances of each case remain paramount. Often, companies list directors and executive officers as affiliates owing to their clear control over organizational matters. However, the law doesn't necessitate this. Several instances have found that occupying these roles can contribute to control within the SEC definition, but they aren't defining factors. Let's dive into a noteworthy case that assists in defining the concept of an affiliate within the context of securities law: Penalties & Co. v. SEC. In this case, Penalties & Co., an Idaho-based brokerage firm, was involved in purchasing shares of a company from controlling shareholders. They then resold these shares to their clients without complying the registration requirements of Section 5 of the Securities Act. The SEC contended that Penalties violated the Securities Act of 1933, as the shares should have been registered before they were sold to the public. Upon appeal, the Ninth Circuit Court of Appeals affirmed the SEC's decision. The court ruled that the controlling shareholders were indeed affiliates of the company, as they had the power to influence the company or its policies due to their significant ownership of the company's voting securities.